heard. The FEC actually had an expert
But
below.
why do that is that the super PAC can't be coordinated. And these party expenditures can be coordinated, so they're more helpful to the candidate because for the reason that the Chief Justice said, they effectively function as contributions to the candidate. There can be, coordination to the max so that everything that the candidate would want is done through these coordinated contributions. And that's more valuable to a candidate than giving money to a super PAC that is generally on the same page but may do things that the campaign actually doesn't want done.
Except that a contribution to a party is limited to $44,000, whereas a contribution to a super PAC is unlimited.
Well,
I think
$40,000, and then you give to the Joint Committee, and then the Joint Committee disperses it, and then it comes back, and it ends up in the party. And altogether, it's not just the 40 plus the 3. It's probably about $500,000, even putting aside the segregated accounts, plus the 3. So you've taken a base limit of $3,000 and you've amplified it into a $500,000 contribution, which is going to exactly what the candidate would put it to himself.
So 2 responses, Your Honor. The first is what I was initially giving you, because, yeah, I recognize the hypothetical you're drawing out, but super PACs have unlimited contributions. And I would much rather have, $10 million of independent spending if I were a candidate than even $44,000 or even $500,000 of coordinated spending. I think you addressed this issue in McCutcheon. But I'll put that to the side and I'll take on your hypothetical directly. First of all, again, I think McCutcheon answers this because McCutcheon directly addressed the joint fundraising context and it rejected it, making quite clear that joint fundraising wasn't a mechanism for evading the base limits or the earmarking rules. But I'd also say, think about how
implausible. Mr. Francisco, even in rejecting the mechanism, even in say that the mechanism at issue there was okay, one of the things that the court said in McCutcheon was that these limits actually served to mitigate any problems that you would have from the aggregation limits that were at issue there.
Sure.
So it clearly conceived of a world in which these campaign coordinated limits would be in place.
Sure, but I think that the joint fundraising theory that my friends lay out in their briefs is the same highly implausible theory that this court rejected in McCutcheon. Think about how it works. I donate to 20 different committees, political committees, candidate committees. All of those committees then agree to transfer all of that money to one committee. That one committee then agrees to spend all of that money for one candidate, all so that one candidate can deliver official action back to me. If this were a real problem, you'd think that they'd have evidence of it occurring one time in all of American history, yet they don't. The reason they don't are the reasons you gave in McCutcheon. And in addition, why would I go through that circuitous scheme rather than just give, call it $1 million, call it $10 million, call it $100 million to my candidate's favorite super PAC, which again is the issue you addressed in McCutcheon.
You keep saying